Okay, let's unpack this. In our increasingly interconnected world, technology and knowledge aren't just abstract concepts, they are uh, undeniably powerful forces shaping our future. But how do we actually manage the rules governing these forces? Today, we're taking a deep dive into something you might not think about every day, but that profoundly affects everything from the medicines you can access to the products you buy, intellectual property or IP.
Yeah, and what's truly striking here is that while the world generally agrees on the importance of IP, protecting inventions, brands, creative works, the ability to actually generate and benefit from it is incredibly unevenly distributed across the globe.
Unevenly distributed. How so?
Well, we're talking about stark differences. Think about Japan or the Republic of Korea issuing well over 100,000 patents every year,
Wow, okay.
compared to a country like Nepal, which back in 2015 granted only two, just two.
Two patents versus hundreds of thousands. That's
Well,
stark is the right word.
exactly. And this isn't just a fascinating statistic. It creates a wildly complex landscape for international trade and investment. It really does.
And that's precisely our mission for you today, to try and cut through some of that complexity. We're looking at a comprehensive handbook put together by the UN's Economic and Social Commission for Asia and the Pacific. It acts as a sort of strategic guide for countries navigating this tricky terrain. Think of this deep dive as your shortcut to understanding how these IP rules and trade and investment agreements impact nations, especially those with maybe fewer resources. We'll uncover surprising facts and key insights.
Focusing on what's most important for you to be well informed and to truly grasp the stakes involved.
Right. So to really get this, we have to start at the beginning, the foundation. That's the WTO Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS. It's the most comprehensive international IP treaty, almost global membership, negotiated back in the Uruguay round, what was it, 86 to 93?
That's right.
So why was TRIPS so revolutionary? What was the big deal?
Well, that begs the question, doesn't it? Why did IP, which traditionally was just a matter for national laws, suddenly become this central trade issue?
Yeah, why the shift?
Basically, industrialized countries, particularly powerful sectors like software and pharmaceuticals, really push for it. They argued that insufficient IP protection in emerging economies created an unfair advantage for local industries, allowed for piracy.
Okay, so it was industry pressure.
Largely, yes. And the result was this single undertaking. Essentially, to join the new WTO and get that market access, countries had to sign up for TRIPS. It was a package deal.
You couldn't pick and choose.
Exactly.
Right.
Now, interestingly, despite TRIPS being so central, only 34 complaints citing the agreement went to the WTO dispute settlement body in its first 20 years.
Only 34. That seems low.
It does. And it led to just 12 decisions. It really hints at how its enforcement primarily happens between countries, state to state, rather than through, say, individual company complaints, and it points to the intricate politics involved.
But TRIPS isn't just about setting minimum standards for patents and copyrights, right? It introduced some other really critical principles, too.
Absolutely. And this is key. You've got principles of non-discrimination, like national treatment, meaning foreign right holders get the same protection as domestic ones and most favored nation. But critically, it also includes elements that allow for a balance between IP owners and public interests.
Ah, the balance. That sounds important.
It's vital. What truly stands out are Articles 7 and 8 of TRIPS. Article 7, Objectives, says IP protection should contribute to technological innovation and the transfer and spread of technology for social and economic welfare.
Okay, so innovation and sharing.
Right. And Article 8, Principles, is even more explicit. It clearly states that member countries can take steps to protect public health and other public interest reasons.
So there's built-in flexibility.
It's exactly. This policy space, or flexibility, is vital.
Yeah.
Think of it like a country having room to maneuver to decide what's truly best for its own citizens' health, its economic development, even when facing these international IP rules.
Right.
This flexibility was so important that the 2001 Doha Declaration on TRIPS and Public Health specifically reinforced it. It stated that TRIPS can and should be interpreted and implemented in a manner supportive of WTO members' right to protect public health and, in particular, to promote access to medicines for all.
Access to medicines for all, that's huge.
It is, and this includes allowing for things like compulsory licenses on patented products.
Which is when a government allows someone else to produce a patented product without the patent owner's consent, usually in emergencies.
Precisely, often for a public health crisis. Or, another example, the freedom to choose a national regime for the exhaustion of IP rights. This impacts parallel imports.
Parallel imports. That's like when a drug is bought cheaper in one country and imported into another without the patent holder's say-so.
Exactly. Importing the genuine product from a market where it's sold for less. TRIPS allows countries to decide their own rules on that.
Okay, so TRIPS was designed with this deliberate balance. Protect innovators, yes, but also serve the public interest. But you mentioned the mid-90s. Did that balance hold? Or did something else start happening?
That's an excellent question. Because, yeah, since the mid-1990s, we've definitely seen a new, more aggressive trend emerge that began to challenge that equilibrium.
Which is?
TRIPS Plus's provisions, showing up in bilateral and regional trade agreements.
TRIPS Plus, what exactly are these and why are they significant? I mean, plus usually sounds like it means more, maybe better protection.
That's a very common initial reaction. It sounds positive, but the core insight here is that while TRIPS aimed for a global baseline, TRIPS Plus provisions are IP obligations in free trade agreements that go beyond those minimums.
Beyond TRIPS.
Yes. Countries, often developed nations like the US, the EU, or Japan, negotiate these, usually in exchange for other benefits, like better market access for goods.
And what do these plus provisions look like?
Well, examples include much stronger copyright protection, especially online, longer patent terms for pharmaceuticals sometimes going beyond the standard 20 years, broader trademark protection, and much tougher enforcement mechanisms.
Like what?
Things like border measures for goods that are just in transit through a country, or extending criminal liability for IP infringements further than TRIPS requires.
Okay, I can see why IP exporting nations would push for that. They'd argue it incentivizes R&D, protects against piracy.
Absolutely. That's the argument. Protect those big investments, especially in pharmaceuticals, software, entertainment.
But I sense a but coming. You mentioned criticism. What are the downsides, especially for developing countries signing these deals?
You're right, there is significant criticism. The primary concern is that these TRIPS Plus standards significantly reduce or sometimes even eliminate the very policy space and flexibilities that TRIPS was designed to provide.
So they erode that room to maneuver we talked about.
Exactly. They limit a country's ability to tailor its IP laws to its specific domestic needs, its level of development, its public health priorities, and they make it harder to adapt to changing circumstances.
How so?
Well, imagine designing really detailed IP rules for technology today. They might be completely outdated in just a few years, right? Think about ISP liability rules written before social media or big data really exploded.
Right, technology moves so fast.
So these detailed technology-specific transplants from one country's laws often don't fit the regulatory environment of the receiving country, and they become incredibly inflexible once they're locked into an international treaty that's notoriously hard to amend.
So these gold standards can actually become a kind of straitjacket.
That's a good way to put it. They can lock developing nations into standards that might prioritize the interests of IP exporting countries over their own public health needs or flexible technological development paths.
And this isn't just academic chatter, is it?
Not at all. You have major organizations, the WHO, the UN, even the EU Parliament, and the U.S. Trade Representative's Office, calling for safeguarding those TRIPS flexibilities, especially the ones related to public health and access to medicines.
So there's widespread recognition that countries need to keep that policy space.
There really is a recognition of the critical need for countries to retain that room to maneuver, to meet their unique national challenges.
Okay, so TRIPS Plus expanded IP's reach in trade deals, but you mentioned a parallel development in investment agreements. That sounds like a whole different ballgame.
It is in some ways. IP started showing up more and more in international investment agreements, or IIAs. And here's the twist. These IIAs often come with investor-state dispute settlement, or ISDS.
ISDS, that lets private companies sue governments directly in international tribunals.
Exactly. And what's fascinating and concerning for many governments is that investors started trying to use this ISDS system to challenge government actions related to IP.
How does that work? How do general investment protections like fair treatment connect to specific IP rights like patents or trademarks?
Well, we've seen some really high-profile cases illustrate this perfectly. Take the tobacco giant Philip Morris suing Uruguay.
Over the plain packaging laws for cigarettes?
Precisely. Philip Morris argued that these public health measures removing branding, using graphic warnings, amounted to an expropriation of its trademarks, essentially claiming the government took their property without proper compensation.
Wow. So using an investment treaty to fight a public health regulation.
Yes. Now, the tribunal ultimately rejected Philip Morris's claims. It upheld the state's police powers, its right to regulate for public health. But the case clearly showed how companies were trying to bring international IP arguments into these ISDS disputes.
Were there other examples?
Oh, yes. Eli Lilly, the pharmaceutical company, sued Canada under NAFTA.
What was that about?
They challenged the revocation of 2 drug patents. Canada had invalidated them based on its promise doctrine.
The promise doctrine.
Yeah, it's basically a legal standard in Canada that requires a patentee to show their invention actually delivers on the specific promises of utility or effectiveness made in the patent application itself. It can be a higher bar than in other places.
Okay.
Eli Lilly argued this doctrine and its application to their patents breached Canada's international IP obligations under NAFTA.
And what happened there?
Again, the tribunal ultimately rejected Eli Lilly's claims, largely on factual grounds, finding the patents didn't meet the standard. But importantly, it underscored that ISDS tribunals are not supposed to act as some kind of super appellate court for national judicial decisions on patents.
So national courts decide patent validity, not investment tribunals.
That was the point. And there was also the Philip Morris Asia case against Australia, another challenge to plain packaging. That one got dismissed on procedural grounds. Yeah, the tribunal found Philip Morris was essentially treaty shopping. They'd strategically restructure their investment after Australia announced the plain packaging policy, routing it through Hong Kong, specifically to use the Australia-Hong Kong Investment Treaty to bring the lawsuit.
Ah, trying to game the system.
The tribunal thought so, calling it an abuse of rights. But the bigger picture from all these cases, it's not just that companies are suing governments. It's that IP has become this battleground where private commercial interests are directly challenging national sovereignty and public welfare policies.
Forcing tribunals to draw lines.
Exactly. And investors who usually don't have a direct way to sue countries for breaching IP treaties like TRIPS, they're trying to use the investment hook clauses like fair and equitable treatment or expropriation in investment treaties to bring these IP-related disputes into the ISDS system.
That's a really important dynamic. So with this complex global picture, TRIPS Plus, ISDS, let's zoom in on the Asia-Pacific region. You mentioned the UN handbook focuses there. What's the situation on the ground? What's this noodle bowl of agreements actually look like?
Right, the noodle bowl. It's a great analogy because it's complex, interconnected, and potentially messy. The data shows over half of the 167 trade agreements involving Asia-Pacific countries that were enforced by 2016 included IP provisions. So IP is definitely a major feature.
But is everyone equipped to handle these complex negotiations?
Well, that's the crucial point. There's a vast difference in capacity. Just look at patent processing times. The average age of a granted patent in Thailand, for example, is almost 12 years.
12 years to get a patent approved?
Compared to just over 3 years in Australia.
Big difference. What does that signify?
It's not just bureaucracy. It indicates significant disparities in institutional resources, expertise, maybe academic capabilities needed to examine complex applications quickly. It means local innovators might wait years for protection, potentially losing out. And it makes developing countries particularly vulnerable to accepting these legal transplants, complex IP rules from other countries that might not suit their needs or developmental stage because they lack the resources to fully analyze or negotiate alternatives.
So for our listeners, this really underlines why things like transparency are so critical, right?
Absolutely. The sources we looked at strongly suggest that opening up negotiation processes, getting input from civil society, universities, not just industry, and doing thorough impact assessments before signing, that can significantly level the playing field.
Makes sense. Ensuring all voices are heard, not just the loudest ones.
Exactly. And ensuring the outcomes are truly beneficial domestically, not just for the IP exporting nations pushing for higher standards.
Does the amount of IP content vary much in these agreements?
Oh, wildly. It's fascinating. We saw one example, a U.S.-Lao agreement, where IP took up 46% of the entire text.
Almost half the agreement dedicated to IP.
Yeah. While other agreements might have very brief IP chapters. So the real estate IP occupies isn't fixed. It's highly negotiable.
Interesting.
And we also see the strength of the provisions, whether they're just general statements or hard, actionable commitments, changes dramatically depending on who is negotiating with whom.
How so?
For instance, really strong TRIPS Plus patent clauses are actually much less common in agreements between a developed and a developing country.
Oh, really? That's surprising.
Except for certain specific areas,
Right.
like protecting test data for pharmaceuticals and agrochemicals. In those areas, developed countries consistently push for and often get higher standards of exclusivity, effectively extending market protection beyond the patent term.
Ah, so it's targeted pressure on specific points.
It often seems that way, yes.
Okay, let's try and bring this all together then. Based on everything we've unpacked, TRIPS, TRIPS Plus, ISDS, the Asia-Pacific experience, what are the key takeaways for you? How can countries approach IP provisions more strategically?
Okay, first, looking at IP chapters within trade agreements. The key message is emphasize the continued relevance of the multilateral TRIPS framework. Don't let new agreements undermine it.
Stick to the foundation.
Pretty much. Ensure new provisions don't erode those crucial TRIPS flexibilities, especially the ones for public health. And avoid getting locked into overly detailed, technology-specific rules that will likely become outdated fast.
Keep it flexible.
And be transparent. Involve all stakeholders, civil society, academics, health groups, not just industry in setting mandates during the negotiations and when implementing the deal.
Yeah.
That leads to more balanced outcomes.
Right. And what about IP and investment agreements? That seems even trickier because of ISDS.
It is potentially trickier. Here, countries need to be really deliberate, very careful. Well, if you're going to include IP rights as protected investments, maybe consider a limited definition. Perhaps require the investment linked to the IP to actually make a positive contribution to the host country's development. Or explicitly tie the scope of the protected IP right to what's recognized under domestic law.
Okay, define it carefully.
Yes, and crucially, safeguard the exceptions and limitations to national treatment and most favored nation that already exist in TRIPS. Don't let broad investment protection language accidentally override those core IP principles.
Protect the TRIPS balance again.
Exactly. And when you get to those really broad investment standards like fair and equitable treatment or rules against expropriation, make sure the treaty clarifies that these respect the state's right to regulate in the public interest and explicitly acknowledge the TRIPS flexibilities.
So prevent investors from using ISDS as an end run around IP law.
That's the goal. Prevent investors from using ISDS as a forum to second-guess national courts or challenge a country's compliance with international IP treaties. Keep those disputes in the proper channels.
Essentially, then, it boils down to retaining that crucial policy space.
Yeah.
Ensuring these agreements genuinely serve national development needs, public health, and don't just automatically favor the interests of IP exporting industries. It's about finding that balance.
Precisely. It's all about balance.
Wow. What a deep dive indeed. From Nepal's 2 patents, all the way to the complexities of plain tobacco packaging and ISDS challenges. We've really seen how intellectual property provisions are far from just abstract legal concepts. They touch on public health, economic development, national sovereignty in really profound ways. Thank you for joining us on this exploration of IP and trade and investment agreements.
Yeah, and stepping back, this whole discussion, it really underscores the dynamic and, let's be honest, often contentious nature of international lawmaking today. You constantly see this tension, right, between the push for global harmonization of IP protection and the sovereign right of nations to craft policies that serve their own unique social and economic welfare.
A constant balancing act.
It is. It's an evolving challenge. And it invites you, the listener, to consider how these seemingly technical legal provisions subtly shape the world around us, the medicines we can access, the technologies we use, the information we share, and maybe ask, what balance do we truly want to strike? For innovation, yes, but also for equity and sustainable development for everyone.